Our next speaker is Paul Steep, who's a senior member of the litigation department at McCarthy Tetro. Paul's going to speak to us on the subject of discipline before regulatory bodies, a subject on which he's well qualified to speak. He serves as both a prosecutor before some professional bodies and defends doctors largely before the discipline committee of the College of Physicians and Surgeons. Paul?
Thank you, Gavin. I'm going to start, since this is a talk on professional discipline, to point out that I do not have a QC, despite what Milt has kindly put in the program. I think it's always useful to know what biases your speakers have when they come before you, so I'm going to declare mine. Although I do prosecute, and I prosecute a lot before the Association of the Professional Engineers, my start in this area of the law was defending physicians, and I still defend physicians regularly before the College of Physicians and Surgeons Discipline Committee, and I'm sure that in my paper and in the remarks that I'm going to make this morning that you will detect a defense bias. You'll later hear in the panel discussion from Jeff Leon and others who've advised panels, so hopefully by the end of this you'll have a balanced view of what takes place before disciplinary bodies in the province of Ontario. What I've tried to do in the paper is to set out an overview and to discuss the principles of law that apply at each stage of these proceedings, from the institution of a complaint through to the issuance of a notice of hearing, the actual discipline hearing itself, the penalty phase, and then how these matters are dealt with on appeal. I want to touch on a few major themes this morning because I think there are quite sharp distinctions that can be made on the law and on the treatment of these matters when you are either prosecuting or defending, depending upon what stage you're at in the proceedings. So, for example, at the stage where proceedings are being instituted, at the complaint stage, as I will discuss, there are relatively few procedural protections available for the professional who's being investigated and complained against. And the issue for defense counsel at that point of view is really an issue of jurisdiction, whether the complaints committee, whether the professional body has defined the complaint appropriately and is conducting an investigation which is within its statutory mandate. It goes without saying, of course, that these are creatures of statute and their jurisdiction only goes so far as the statute permits. They have no inherent jurisdiction. So at that stage, you're really focusing on what jurisdiction can safely be invoked against the member. At the point where a notice of hearing is issued, which I will discuss as being comparable to the laying of a criminal charge, the primary issue at that stage does become one of procedural fairness, and you'll see that the law is developed to provide a fairly high degree of procedural protection for professionals who find themselves facing charges of professional misconduct or incompetence. And the thesis that I'll put before you as we go through the cases is that there is an increasing level of procedural complexity to actual discipline hearings, and I think that that will continue. I think that these proceedings will become more and more like criminal proceedings, and to a large degree they reflect that trend already. The elements that you can see in that criminalization of the process is the fact that the charges have become more formal. The disclosure that occurs prior to an actual hearing has taken on the character of the type of disclosure you would expect in a criminal proceeding and in accordance with the principles that are laid down in Regina and Stinchcombe. And the standard of proof that is required in a disciplinary hearing, although it is still described in many of the cases as a civil standard of proof, approaches the standard required in a criminal proceeding, and I'll take you to some cases which discuss it being close to but not exceeding proof beyond a reasonable doubt. It's important to look at these disciplinary proceedings in a context of overall administrative decision-making. As I'm sure you're all aware, that the administrative decision-making runs the whole gamut of routine statutory decisions being made by administrative officials, and then on the high end of the scale, discipline proceedings of these sorts where the allegations are in the nature sometimes of criminal conduct. I'm going to discuss briefly the Court of Appeal decision in Howe versus the Institute of Chartered Accountants, but it's a good launching point because Laskin commented there that these types of proceedings really approach the judicial end of the scale, meaning that these are really comparable to the types of decisions that you would expect a court to make and have less of the character of true administrative decisions. As all of you will appreciate, being professionals yourself, the revocation of a professional license, a significant suspension from practice is the equivalent of a fine of really monumental proportions that can often exceed the type of penalty that is imposed in the criminal law and certainly in the civil law, so that it makes sense to approach these as really judicial type decision making. Now, as I said in the overview, the complaints process really raises an issue of jurisdiction, both for the body who is processing the complaint and for counsel to the professional who is under investigation. And in my paper, I highlighted two areas of concern that you should have pay attention to whenever a complaint surfaces involving a professional client. Typically, the complaint will come to a professional body in an informal way, by way of a telephone inquiry, by way of an informal interview. And the issues there are twofold. First of all, when is there a complaint which is filed with the registrar? Because in my experience, the practice for professional bodies is not to treat the first informal inquiry or even the first written letter of complaint as the actual filed complaint. Very often they send a professional investigator out to interview the complainant or to formulate the complaint into precise or more precise language that mimics the statute that is in issue. Secondly, at the complaints committee stage, you cannot always count on seeing the actual complaint formulated by the complainant. The statute provides that members of the profession, certainly in the health disciplines area, involving all of those professions that are governed by the Health Professions Act and the Code, it's also true of architects and engineers, that they get notice of the complaint. And so typically the notice that is given to the professional does not necessarily include the actual text of the original written complaint from the complainant. The complaint, of course, will set the boundaries for the subsequent investigation. And so that's the other reason for why it is necessary to pay some attention to the parameters of the complaint. Professional bodies cannot easily conduct investigations of professionals at large. In most of the professions, certainly in the health professions and again in the engineers, there are separate powers of investigation conferred on the registrar of the profession, but in order to invoke those, independent of a complaint, the registrar would have to be possessed of reasonable and probable grounds. They would have to get an order of the executive committee of the profession, and they would have to act thereafter in accordance with either a formal order of the executive committee or a formal appointment. So you want to make sure that the complaint has been defined appropriately so that when the professional is responding, he's responding or she's responding within the context of the matter that is properly before the professional association. From the association's point of view, at this stage when a complaint may or may not be filed, it's important to be honest with the professional. There have been practices, the engineers were subject to some recent criticisms on this, where in the context of considering a complaint, the member, the engineer, was contacted by the investigator and asked to provide information without formally being put on notice that he was the subject of an inquiry that would likely result in a complaint which would proceed to the complaints committee. This was commented on by the divisional court in an unreported decision, which I've cited on page 6 of the paper, and Nasral and the discipline committee of the Association of Professional Engineers, as not being appropriate. And clearly the better practice is to make sure that the professional is aware that he or she is under investigation at any point when they're asked to provide information. This makes sense in the context of some of the other law that is developed within these professional bodies. It's usually taken for granted that the professional is under an obligation as a holder of a license or the privilege of practicing to respond to the professional body whenever an inquiry is made. Now, I want to turn next to the notice of hearing. The notice of hearing is, as I've said in the opening, comparable to a criminal information, although I want to emphasize that it's not always treated precisely that way. A notice of hearing will contain a specific allegation of either professional misconduct or incompetence or both, and pursuant to the Statutory Powers Procedure Act, will be supported with fairly detailed particulars so that there is notice of the conduct that is in issue. Now, as defense counsel, we often try to treat these as criminal informations. We try to define the charge, needless to say, as narrowly as we can, and to put the prosecution to a position of having to prove the elements of that charge. The courts have not been supportive entirely of this point of view. The leading decision in this area is the Milstein and College of Pharmacy case. I've set out the relevant excerpts of that at page 10 of the paper, and I think it's clear that the way the courts prefer to look at these is to say that the charge is just the allegation of professional misconduct. The specifics that are alleged thereafter, either by referring to specific regulations within the statute, and for example, there's a specific definition of negligence in the Engineering Act, and then sub-definitions beneath that, are just by way of notice. The particulars alleging facts are just by way of notice, and that it's not appropriate to treat these in all respects as setting out counts as you would expect to find in a criminal information. Now, having said that, close attention should always be paid to the language of these, because if you're calling a defense, you can very often convince the discipline committee, and I'll give you the example of defending a physician who is alleged to have committed sexual impropriety with 3 separate patients involving 3 separate factual incidents that are supported in particulars. It often happens that one of those cannot be made out by the prosecution, and they will entertain at that point a motion on the notice of hearing to dismiss what I will refer to as that one count, so that you don't end up having to call any defense in respect of that, notwithstanding that there is an argument that the charge itself is simply professional misconduct and that these particular allegations are by way of notice rather than true counts in an information. Once you have the notice of hearing, you'll go through some form of pre-hearing disclosure. And I have set out at pages 11 and following a discussion of the Court of Appeal decision in Howe and the Institute of Chartered Accountants. I've paid attention in this to the dissent of Laskin because, as I'll conclude, I think that Laskin's dissent is actually quite illuminating as to how disclosure is really conducted before disciplinary panels, and I think it will more and more become the way that discipline committees prefer to deal with this. In how the majority dealt with the appeal that was taking place, which was for the production of an investigation report that had been prepared by the Institute of Chartered Accountants as an issue of prematurity. But in the majority decision where they recite the facts, they note that the chairman of the committee who was making the decision against disclosure, choosing to uphold a claim of privilege on the four-part Wigmore test, had also stated that he did not necessarily think that the principles of Regina and Stinchcombe had application to disciplinary proceedings. Now, you must take from that that the Court of Appeal was aware of that, and they did not believe that any of that resulted in a loss of jurisdiction. Laskin, on the other hand, did think that that was a fatal jurisdictional error, and he then gave, in my view, a very thoughtful discussion of the principles of disclosure. And I've set out the three principles that he said would more properly inform the decision-making of discipline committees, which in practice, I think, are the principles that discipline committees do listen to. First, the mere notice requirements of the Statutory Powers Procedure Act are no longer enough to satisfy the disclosure obligations. There has to be something beyond that to allow the professional to make full answer and defense. Secondly, there is a desire on the part of the discipline committee not only to conduct an efficient hearing, but to assure themselves of some element of fairness in proceedings which otherwise don't contain any formal production or discovery techniques for defense counsel. And third, he pointed out that notwithstanding the majority's opinion, as a general proposition, courts will review issues of disclosure as jurisdictional defects, so that it's in everyone's interest to ensure that full answer and defense is made possible through adequate disclosure prior to the hearing. At the College of Physicians and Surgeons, for example, they entertain fairly sophisticated motions for production in advance. In the sexual impropriety and sexual abuse cases, it's routine to have formal O'Connor applications. I, in anticipation of this talk, checked the FACTA that we file in criminal proceedings against the FACTA that we file before the College of Physicians and Surgeons. They're really no different. There's a formal argument on law. The committee goes through the same two-part test. They determine the likelihood of relevance. They review the documents. The physicians are there under subpoena. And I think that this is really the example of how these proceedings are coming to resemble more and more criminal proceedings, and how these committees are really interested in ensuring that there is a high level of procedural fairness before the hearing begins. With respect to the discipline hearing itself, I want to touch really only on the standard of proof issue. And it's to say this: I've put in the paper a detailed discussion of the Bernstein decision, which is often recited by rote as the standard of proof for discipline committees. being on a balance of probabilities but supported by clear and cogent evidence. I mean, no disrespect to the committees, but when it's summarized in that form, it really does an injustice to the type of guidance that the court set down for disciplinary panels in that decision. And it's worth reading every time you have to give an argument before one of these panels to remind them of the care that is required in assessing evidence. The court was quite clear that the panel was under an obligation to conduct a very careful and thorough review, that they had to have an eye out for fragile or suspect testimony, and they really set out what amounts to a sliding scale of justice in the sense that they also have to be cognizant of the seriousness of the fact that will be found on that particular evidence. And to give you one other example from the sexual offenses that are prosecuted before the College of Physicians and Surgeons on the penalty provisions, now there is mandatory revocation for certain acts of sexual misconduct that are found by the committee. So in other words, as soon as they make that finding of fact, the conclusion is a predictive one. The physician will lose his or her license. So the quality and quantity of evidence that supports that type of conviction has to be of the highest standard. Now, let me then turn to how these issues are dealt with on appeal. And you'll really find in the case law two quite contrasting approaches. The first, which is the approach of judicial deference, is really articulated most strongly by the Ontario Court of Appeal. And I have set out some of the excerpts at page 22 from the Delcor and College of Pharmacy decision, where Mr. Justice Finlayson really laid down a fairly strict edict for the divisional court. And there were two areas of judicial deference that he really wanted the divisional court to pay attention to. The first was to give recognition of the fact that these are self-governing regulatory bodies for a specific reason. They have what he described as unique qualifications to judge their fellow peers, and that that type of insight into the profession ought not to be lightly interfered with. Secondly, he was very critical of the painstaking approach that the divisional court had taken in that particular case to overturning the committee's decision. And the specific issue there was simply that the court had relied upon, or excuse me, the committee had relied upon the pharmacist's knowledge or alleged knowledge of the operations of a pharmaceutical company without evidence before them. And the Court of Appeal clearly thought that these professional pharmacists were entitled to presume that knowledge. And at the bottom of page 22, you'll really see what could be described as a somewhat stinging rebuke of the divisional court when they said that the Court of Appeal said that you just don't hold up decisions of disciplinary bodies to that type of painstaking review. So that's really the high watermark for judicial deference. Now, you will find, and in my experience you find this most frequently at the divisional court, and I've set out the example of the Quiog case, and the discussion of that case is found at pages 23 and 24 of the paper. It was a case involving the College of Nurses, and it really involved a reconsideration of findings of credibility that the discipline committee had made. I won't deal with the first one, which is set out in the paper, because it's easy to characterize that ground of appeal as a clear error of law. They had misapplied evidence of the complainants to diminish the complainant's credibility simply because there was no evidence of bad character on the part of the nurse. But the remaining 2 grounds, and particularly how they dealt with the evidence of persons who had received the first reports of so-called sexual abuse but had failed to pass them on, is quite interesting, because as I point out there, it really amounts to nothing more than the divisional court accepting an explanation which the discipline committee had heard and decided that they did not accept. So in other words, the divisional court felt comfortable going in and weighing the evidence. So despite what you see in the Court of Appeal decisions, if you're thinking of an appeal, in this case it was an appeal by a college, so I'm sure that had a lot to do with it. It was not an appeal by the member. There's scope for these appeals. I'm grateful to Jeff Leon because he pointed out to me a very recent case of the British Columbia Court of Appeal, which I've set out at page 25. It's a College of Physicians and Surgeons versus someone who's only identified as K. It's a very interesting case, and it sets out, in my view, a much more intelligent view of what the court should be doing on review. The same issues as in Quiog really came up because they were assessing issues of credibility, but they chose to approach it quite differently and to say it was really a question of the court looking at the reliability of the evidence and again applying the high standard objectively of what evidence was before the committee. They were specific in saying that they were not weighing the evidence. They were looking objectively at the inherent weaknesses of the evidence and concluding as a matter of law that that evidence simply did not meet the standard of clear and cogent evidence required of a disciplinary panel. I've set out at page 27 and following some observations on penalties. Really, penalties can run the whole gamut from a reprimand through to revocation. And as I point out, because professional licenses are involved, there is great opportunity for conditional sentences, and I mean by that the imposition of conditions, sometimes quite complex conditions, on a license as a result of a finding of professional misconduct or incompetence. Just to highlight some trends here, if you're looking at decisions of bodies, and some of these professional bodies have quite long histories of decision making, which you can look at when you're trying to get to sentence. I think there's been a notable shift since about 1990 to much more serious penalties. It was quite common throughout the 1980s to be able to get unrecorded reprimands of professionals who were convicted on a first time of professional misconduct. That type of thing has virtually disappeared. Closed hearings are still technically possible in some professions. They are at the engineers, but they're virtually in practice unheard of. These hearings are open. The committees feel bound that the penalties be published, and because of the public interest nature underlying most of these statutes, there's very strong interest in these professions that are all self-governing, demonstrating to the public that they are actively pursuing issues of general deterrence, so that sentences that were passed as recently as the late 1980s may not provide much of a guide to what will happen now. I do point out one thing about conditional sentences which you should be careful about. We have a lot of experience with these at the College of Physicians and Surgeons. They're a favorite weapon against physicians to get them retrained. And often they can have the effect, if you're not careful, of circumscribing the order as much as you can, of getting the physician trapped into a disciplinary process where the continuation of the license is really dependent upon the discretion of someone who's conducting retraining. For example, they often ask for undertakings that the professional will continue to take courses that are recommended after an evaluation of his or her professional skills. Now, I think at some point you can very fairly argue that you stepped outside of the jurisdictional bounds of the discipline committee, which is there to penalize for specific professional conduct, and into the realm of mandatory retraining, and you can squeeze the order back accordingly. The conclusions, I think, from all of this are difficult to predict. I think, however, that if you read those cases that I've cited in the paper carefully, it's safe to predict that the level of decision-making expected of these bodies will continue to rise, that they are being reviewed now virtually as a court of first instance would be reviewed. And there are good reasons to think that that will continue to be the case when these cases go to court. First of all, there are many more of these proceedings. As Gavin pointed out, many professions that were not regulated this way now are. Secondly, the penalties are clearly more serious, and a lot of the offenses approach the nature of criminal conduct. They result in the most serious penalties, revocation. They often have accompanying them very serious civil actions or criminal proceedings. It's very difficult to control the pacing of the disciplinary proceeding, and I mean by that that sometimes the disciplinary proceeding comes on before either the civil proceeding or the criminal proceeding. And if that's going to occur, then I think that courts have a predisposition to ensure that the professional has the highest possible battery of protections available to advance his or her defense before his professional body. I think that the public interest underlying these statutes is going to continue to create pressure on disciplinary bodies to prosecute these types of offenses and to do so quickly. And if they're going to do that really as a court of first instance, then they are going to have to provide all of these protections to the professionals if they're going to survive challenges on appeal. And of course, it goes without saying, with revocation, serious allegations that will be contested in criminal or civil parallel proceedings, there will be more appeals. So it's just a fact of life that these bodies will know their decisions will be appealed, and they will begin to conduct themselves more and more like courts. Thanks.
For our panel on professional discipline, let me introduce the two additional members of our panel, other than Paul. On my right, Jeff Leon, who's a partner and a senior member of the litigation practice group at Campbell Godfrey. Jeff has a broadly based commercial litigation practice for our purposes, in addition to the commercial and professional liability work that he does. He also serves very frequently as one of the independent counsel to the Discipline Committee of the College of Physicians and Surgeons. And on my left is, of course, Brian Greenspan, one of our leading criminal lawyers. In addition to the work he does in the criminal courts, I know Brian, through the work I've done, as one of the leading defense counsel in professional discipline work, certainly before the Law Society, but also before the Securities Commission and various other bodies. Brian, I'd like to start with you, if I could, by asking you to comment on what strategies you like to adopt where you have a client who is both charged with professional misconduct or conduct unbecoming or incompetence before a disciplinary body, and who is also either facing criminal charges or at risk of facing criminal charges?
Well, there's a variety of answers and a variety of strategies, and to some extent it depends on the discipline tribunal before which you're appearing. There's an obvious tension between the discipline bodies desire to fulfill their public mandate by efficiently and expeditiously disciplining their members. And in fact, they feel a little bit concerned about the whole issue of self-regulation and governance of their profession, to make it at least appear publicly that they're fulfilling their mandate in an effective and expeditious way. On the other hand, from the criminal accused perspective, obviously one doesn't want to disclose anything until one has to. And obviously, if there's going to be a hearing, particularly in those professions where there is to some extent, some reciprocal disclosure obligations, if there's going to be a hearing in the tribunal before the criminal case, you're in serious trouble. And there's trouble in terms of trying to protect your position criminally, trying to protect the idea that you don't wish to disclose the defense, and you want to hear everything first before you respond, both civilly and criminally. So there is a variety, first of all, in terms of the Law Society. The Law Society very frequently makes a demand that there be an undertaking not to practice if you're going to postpone the tribunal hearing. And even then, when the public profile gets too great, and despite, and I can use a couple of names here that have come to public attention, and a good example is in Eagleson. Eagleson hadn't practiced law in over 10 years. He was more than happy to undertake not to practice. He was more than happy to, and somehow was extorted to not to use the designation QC publicly during the course of the time it would take to resolve his matters criminally. And the Law Society wasn't content with that. They wanted to press on. They wanted to somehow fulfill publicly their responsibility, and it took a great deal of negotiation, a great deal of effort, and really not until the time where the criminal matter seemed to be proceeding on to its negotiated resolution was the Law Society prepared to back off, so that they want to push forward and push forward expeditiously. Almost the antithesis can be seen in Nova Scotia in the case of Dr. Morrison, where we just quite thankfully successfully completed her criminal matter. There has not been a word out of the college in Nova Scotia with respect to proceeding with the discipline matter that is pending. They simply were prepared to abdicate their role in the process until such time as the criminal matter was resolved. Midway between that is a position that the College of Physicians and Surgeons recently took here. They were prepared to step aside in the case of a Welland physician who was charged with two historical allegations of sexual misconduct with patients. They were prepared to wait for those complaints to come forward. But there, what can trigger something that is unexpected is the complainant, after being somewhat patient, at least according to the complainant's position, somewhat patient, waiting for the criminal matter to resolve, can demand through the Health Professions Board a hearing. And the Health Professions Board then can demand of the college that it proceed in an expeditious way to hear the complaint. And recently we had one of those hearings. Fortunately for the Welland physician, his criminal acquittal took place 4 days before he was to appear before the Health Professions Board, and so that was of some assistance in resolving the matter. So the strategy must be, if at all possible, postpone. But many of those postponements must be negotiated with counsel on behalf of the discipline tribunal. Much of it has to be negotiated in terms of profession to profession. And even in the case of the resolution of a criminal case, you have to think of the fact that there then might be an appeal should there be a conviction, and that sometimes will further postpone the result. One of the attractive parts, and final comment, one of the attractive parts of the postponement is you can appeal to the tribunal by simply saying that if there's a criminal conviction, that in itself will resolve all the problems before the discipline tribunal. Because even if you have a series in what could have been a lengthy hearing before discipline, if the person's convicted, in almost every profession, a criminal conviction will amount to conduct unbecoming that professional. So they can replace the specific allegations of professional misconduct with a blanket charge or a blanket allegation of conduct unbecoming, to which the person inevitably has to plead guilty, and they can have their result and their penalty from a discipline perspective without the necessity of an extended hearing.
Let me ask you, Paul, if you could comment on the question of what strategies you adopt if your client is facing, say, a medical negligence action at the same time as he or she is facing a charge of professional misconduct before the college. Is there any hope of having the hearing postponed while the civil action is outstanding?
Well, there's hope of it. I mean, it depends very much on what position the college takes and what, frankly, their scheduling requirements are. I don't think the strategies are much different than those that Brian has already gone through, but from the civil point of view, you might, and we do on occasion, approach it differently. For example, because of the standard of proof issues where there's a civil action involving allegations of sexual impropriety and a college proceeding, but no criminal proceedings and no likelihood of criminal proceedings, we might be content to proceed with the college proceeding first. We might evaluate our chances of success at the college, and clearly whichever proceeding goes first, we want to win that first as being higher. So for example, if there's a single complainant and allegations that are old and applying the standard of proof that I was just talking about, you might have a better case at the college than you would in a civil proceeding. The second thing that I would say, I was gratified to hear some of the discussion this morning about the parties being quite distinct in both proceedings. I touch on that in my paper. I mean, it's often equated that you're facing the complainant at the college. You're not. You're facing the professional association. The offense is often defined somewhat differently, and in my experience, although it's certainly not universal, civil judges have been reluctant to import much from the college proceedings into civil proceedings. Now, there certainly have been cases where that's occurred, but as a general proposition, no. The long and the short of it is you have to have your defense planned out for both the civil proceeding and the college proceeding, obviously in tandem, and then try to proceed with the one that has the highest chance of success first.
Jeff, as I mentioned, you've done a lot of work as independent counsel to tribunals, disciplinary tribunals, and I wonder if I could ask you to comment on what some of the challenges and pitfalls of that are, and specifically also how interventionist you feel comfortable in being. For example, do you speak only when spoken to, but like a child, or in the case of my children, they speak whether they're spoken to or not, of course. But do you intervene only when asked, or if you see the hearing going off the rails, do you feel comfortable in intervening?
Thanks, Gavin. The principle that I operate under in acting as independent counsel basically stems from, I think, what's been accepted by the courts in Ontario, that a discipline committee is entitled to have the legal assistance of its own counsel in the course of a hearing. And the question of how far counsel can go in providing that legal assistance is one that's been debated back and forth, both among counsel and and in court. The issue is often one of degree. My general approach in acting as independent counsel is I'd rather be reactive than proactive. I'd like to be able to sit there, let the hearing go ahead, and only give my advice when asked for it, assuming that anything that is going on at the hearing in terms that may be objectionable will be dealt with by one counsel or the other counsel. So my preference is to wait till I'm asked for advice. Unfortunately, that isn't always the way things go. there are situations where counsel can be abusive of the panel, trying to run the hearing or take the running of the hearing away from the panel, in which case I consider it appropriate for me to intervene and let the panel know that exactly what their authority is in terms of the conduct of the hearing. Not to make the decision for them, but simply to remind them of what the law is and what they're entitled to do in terms of their own process. The second situation where I might intervene is where I perceive there is the potential for a serious error of law to be made, and counsel aren't responding to it. And that may be for proper reasons. I mean, many counsel don't want to seem too interventionist, particularly before an administrative tribunal, so they hold back, not wanting to make too many objections. In those circumstances, if I think there's for example, something that's totally inadmissible about to go into evidence, I may choose to at least raise the issue, and often the way I'll do that is, rather than simply jumping up and giving my advice, I will say to the chair of the tribunal that suggests that they may want to seek from counsel their submissions on the admissibility of a point, or on whether something should be tendered in evidence or not. So I try to be as neutral as I can be, but there are times where I think you just have to intervene. What that means in terms of counsel appearing before a committee where you have an independent counsel is that, my suggestion is, don't ignore the fact that there is an independent counsel there to the committee. Often you see the situation where counsel kind of treats you as more or less a nuisance that's there, who's going to interfere with their ability to make submissions to the committee. I think you can probably assume that the committee is going to turn to its own counsel for legal advice on an issue that comes up, and therefore, my suggestion to you as advocates would be to try and use the independent counsel to your own advantage. I mean, as much as provide the independent counsel in advance with the authorities you're going to rely on, so that he or she has a chance to review them, consider them, and use them in formulating his or her own advice. Again, it is advice, and I think the one guiding factor that we try to follow in acting as an independent counsel is that you leave the decision making to the tribunal, and simply give the advice on the law, although that often becomes difficult, particularly when you're dealing with discretionary issues involving evidence.
Brian, one phenomenon that I've certainly encountered often in discipline proceedings is the tribunal that becomes too involved too interventionist in the examination of witnesses, and borders on losing their judicial demeanor and descending into the arena. It happens very, very frequently. As a defense counsel, what do you do when that happens? Is it a good idea, for example, if your client is being questioned at great length by a member of the panel in such a way as to suggest that the panel members join the prosecution team? Is it a good idea to interrupt at that point? Does it do any good? Do you ruin your chances on appeal if you don't intervene?
First of all, I'm shocked to find that lawyers at the Law Society and a tribunal are proactive and involved and engaged in cross-examining people. But this is the antithesis of what Jeff was referring to, the abuse of counsel, and independent counsel intervenes. Then you have the abuse of tribunal. And it's not much different than the interventionist judge and the responses that we all have as litigators to the interventionist judge, and how we have to balance all of the interests that Gavin has briefly reviewed, are to some extent a function of style, purpose, perhaps experience. Certainly my answer today and my response today is different than it was 10 years ago, and I assure you markedly different than it was 25 years ago. There's no question that I feel more confident in the process of confrontation with a tribunal or a judge today than I did when I was less experienced. And I feel more confident in trying to, first politely but firmly, pointing out that they've entered the arena. Perhaps, if necessary, pointing out just briefly some general principles that might be involved in the appearance of fairness to the accused or to the participant in the hearing. And those things can be done in a polite and courteous way, but firmly. I think it might be, on occasion, at an appropriate break in the proceedings, a time to enlist the support of independent counsel, if independent counsel is prepared to listen to you, to tell them to go back there and tell them that they're at the point where the divisional court is going to look at this record and they're going to see how unfair and how interventionist and how aggressive this tribunal has become, and that they're going to look bad. And that's probably one of the things that finally alerts the tribunal to the idea that they may be reviewed and that their decision seems to have been preordained. But I think that notion of appealing to them being fair, because they all think that they're being fair despite whatever cross-examination they may be conducting, should be brought to their attention. It shouldn't be left unsaid, and particularly you have to build a record so that it looks like it. Always reminded me of the time when, as a young counsel, somebody said, you have a great appeal. Scotty McCrae, who was a county court judge in Toronto early on in my career, fell asleep during this judge-alone trial. And he was asleep for over an hour. And I was delighted, took a look at the transcript. Nowhere does it say, Your Honor, wake up. Well, the record has to be built. If it's interventionist, if it's offensive, you have to make sure that the record reflects the fact that counsel just wasn't letting it happen in some way, perhaps politely, but I think more firmly, you have to bring it to the tribunal's attention.
There's a useful case that I came across recently. It's the Newfoundland telephone case in the Supreme Court of Canada, and there's a passage in the judgment of Mr. Justice Corey, which is to the effect that there are tribunals and there are tribunals. If they're performing largely regulatory functions, the situation may be quite different. But if they're performing judicial functions, such as this, a tribunal is going to be held to exactly the same standard as a trial judge, insofar as reasonable apprehension of bias is concerned. And that was applied in a decision of the Nova Scotia Court of Appeal, which I think is as yet unreported, called Solicitor X re Nova Scotia Barristers Society. Paul, you touched in your paper on disclosure issues, which are becoming much more common than they were certainly prior to Stinchcombe. But is there, could you talk to us just a little bit about what the common issues are, the most troublesome issues to cope with from the vantage point of counsel on both sides?
Well, I actually think that the most troublesome issue is the overbroad request for disclosure. I notice that people tend to put in their requests for disclosure, just give me whatever you happen to have in your file, and it becomes troublesome certainly when independent counsel is advising the committee to try and delineate what might be a fair request for disclosure from what is, quite frankly, a fishing expedition. So the first thing I would say is that when you're building the paper trail for disclosure, you've got to make sure that the request is focused, because when you get to the motion stage, all of that is presumably going to be in front of the committee, and they're greatly influenced, at least in my experience, by what they perceive to be the fairness of the party requesting disclosure. As I said in the talk, I mean, some of these disclosure motions are quite formal, certainly the ones that are based on O'Connor, and we run through the same set of steps that you would run through in a criminal preliminary inquiry to obtain disclosure. We have the physicians who are in possession of the medical records under subpoena, and waiting in the anteroom at the College of Physicians and Surgeons. We file a formal factum. We run through the test. They're given advice by independent counsel. And these, of course, are usually hotly contested motions, so you really have to lay the groundwork for the semblance of relevancy that you'll need to get the panel to even review the records. The other issue that we, looking down the road when we're going to go to a hearing, often consider in the context of disclosure is whether or not we want to have a severance motion at some point. I was talking to Jeff about this last week, and although there have been dozens of severance motions, I don't think we've ever been successful on more than one or two occasions, but we're always concerned about how similar fact evidence will be used in any case where allegations, serious allegations like sexual impropriety, are going to be used at the hearing. So you want to get, obviously, whatever you can in the nature of statements or written records of what these individuals are going to say, and you want to get those as early as possible, because you may want to lay the groundwork not just for a defense but for a severance motion in front of another tribunal. And we are just building a record, of course, because if we have no realistic prospect of necessarily obtaining all that information or being successful on a severance, it really doesn't lessen our duty to make sure that we've done everything that's necessary to appeal the decision down the road in the event that all of that evidence does go in and is used to convict. So in my experience, those are the most troublesome issues, and essentially I'm saying something that's quite obvious. You have to be thinking about how this is going to play out when you finally get to the hearing or may have to conduct an appeal.
One thing counsel talk about a lot if they appear both before tribunals and before courts is whether they approach the two functions differently as an advocate. Do you, Jeff? What's your view on that?
I think you have to, Gavin, or at least you should. In acting as independent counsel, you do get a unique perspective on the difference between tribunals and judges. And tribunals, members of committees, in my view, tend to approach things on a more general, I guess, ordinary person basis, if I can put it that way. They don't understand why lawyers come into the room and don't say good morning, because generally when people start meet each other, they say good morning. They don't understand a lot of the I guess normal civilities that don't appear in a courtroom. And so I think that often when you appear before a discipline committee, you do have to take a step back. The committee members are not trained as judges, and you have to consider how you treat people in the in normal everyday life. The other thing that comes up often is how you treat witnesses. Often I've seen committees interpret aggressiveness as rudeness, and they don't understand why you just can't ask your questions in a nice sort of way and get the answers that you expect to. If I can be permitted one war story, I mean, I remember very early on in my career acting for a nurse before the College of Nurses, where she was charged with having, among other things, having abused a patient on a particular date. It was one of those classic Perry Mason situations, which I never see in my practice. I'm sure Brian sees all the time, but I had a death certificate showing the patient died 5 days before this incident allegedly took place, and I was sitting there holding it in my hand just waiting to use it. I finally used it. The witness broke down and cried, and the committee chastised me for being too rough on her in my cross-examination, and why did I have to make her cry? But that's actually instructive. You do have to try understand that a lot of these people who act as members of tribunals don't appreciate exactly what it is you're trying to do as counsel. And sometimes you have to explain, and sometimes you have to approach it in a slightly different way so that they do understand and see the reasoning behind what it is that you're doing. The other area where I think the difference comes in is how you deal with your legal submissions. Often you see lawyers come before a tribunal and they plop the case book in front of the tribunal just like you would before the judge, and start at case 1 and work your way through to case 23. And you know, I can tell you time and time again, on the breaks, the committee members say, well, what, you know, why is he or she doing all this? What does this mean? One of the things that I think you have to do in appearing before tribunals, perhaps even more so than you do when you appear before a court, is make your submissions in a way that helps the tribunal write their reasons. Think of how you would approach this if you were the tribunal writing your reasons, and that's the way you should make your submissions, because I think that's the way they'll appreciate them more, and you'll get more out of it.
Just a brief comment on that. It seems that's the great contradiction of discipline work and tribunal work generally, because the two lawyers on either side are engaged in what they view as being a totally adversarial process, and they're lawyers engaged in that contest. Particularly the specialized committees that are dominated by members of the profession, or that profession, the health profession in particular, have no understanding of the adversarial search for truth. And they have no real appreciation that that's how, by banging heads, we as lawyers have come to arrive at a just conclusion. And either you have to, from an advocate's perspective, reduce the level of the adversarial nature of that process by becoming perhaps less aggressive or less adversarial, or these specialized tribunals just have to be educated, and educated more and more by lawyers bringing them into a room and telling them what that process is all about, and so that they appreciate it more acutely.
We're running out of time, but since Brian is here, there's one other subject on our list, which we're about halfway through, incidentally.
Exactly.
But I thought we'd cover one other subject in light of your recent experiences, Brian. Just could I ask you whether you could give the rest of us any pointers on dealing with the media if we're involved in discipline proceedings, acting for a professional who would like to keep his or her name out of the newspapers?
I don't know why you'd ask a member of the Greenspan family that question.
Yeah, you seem to be very unsuccessful at it now that I think of it.
We seem to have different approaches to it as well within the family. We have a disagreement. Generally speaking, and it may not seem this way when you see professionals in relation to whom reports are made and newspaper articles are written, I think the lawyer's role is to try to control it and to try to keep it as low profile as possible. I mean, the best job done for a professional client is that their name never appears in the newspaper. And somehow you try to eliminate that level of exposure. Having said that, once someone's onto it, and once the newspaper reporter gets wind of a particular issue, then I think it's usually, first of all, I think it's inappropriate ever to comment on the merits while the matter is still before the tribunal. You simply shouldn't comment on the allegation nor the defense, other than the generalized, this person intends to vigorously defend and vigorously objects to the characterization of this or that. So in a reactive way, I think it's appropriate to make those generalized denials without ever specifically addressing the merits of the case. I think it's appropriate to advise the press about process, what's going to happen, where things are going to be, the fact that next week is a non-event, the person isn't going to be attending, or next week the following will take place, and you might generally indicate what motion is going to take place. So informational guidance is just fine, and I don't think there's any problem with that. I think that the worst, and this is actually the American Bar Association had a survey during the O.J. Simpson trial and had some very useful tips on how to handle the media. They start with the premise that in their survey, the only vocation less respected than lawyers are journalists, and that it's a function of the fact that you have to understand that they're going to hurt you if they can. And that's the way you have to approach them. They are going to put the worst spin on your client's involvement in the allegation, and the worst spin on every word you utter if they have that opportunity. So you have to begin to think in sound bites. You have to be very, very brief. You have to think ahead in terms of what you're going to say very succinctly, something that they can't, a sentence that they can't break up. So they actually have to give you your sentence. So that they can't just take part of it. And even then, Marty York was able to do it every time out. He really is an insidious character. But you know, so that it really is a very, very difficult task, and it's one that we're not trained for. It's one that the only reason I have any, I began to have some interest in it because of some high-profile clients where you had to meet the media, respond to the media, and you have to always be very suspicious of what they're doing, what their intention is, and the fact that they'll never believe you. Never believe you, ever, in terms of what you're saying. They may report it, but they're not going to adopt it.
Thank you. Although we're out of time, I think we could probably entertain a question or two if there are any that people are dying to ask. If not, we'll be back at 2 o'clock. Thank you.